We're going to begin a discussion of Chapter 6, which, according to your textbook, is entitled Civil Rights. Now, before we begin this chapter, make sure that you go back and review the differences between civil liberties and civil rights. Make sure you understand the difference between them. I'm not going to go over it now, but ensure you have an understanding of the difference before the exam. When we look at civil rights, when we look at textbooks that deal with civil rights, some textbooks choose to call the civil rights chapter the equal rights chapter. And I believe that there's a problem there, because when we talk about equal rights, we as Americans, and as we have talked about before, sometimes are misled by that word equal. As I talked about last chapter, which of these two equations is truly equal? I'm not talking about theoretical math here. I'm talking about, when we look at it, which of these two equations are equal. And obviously, 2 equals 2 means equal, because they are exactly the same on both sides of the equal sign. And if we have that definition of equal, then we're going to be very, very disenchanted with the way that the governments in this country work. And if we say that our government has to guarantee everybody equal rights, and we use this definition of equal, again, we're going to be very disenchanted. But if we go back and realize that civil rights mean that we treat people equitably instead of exactly the same, then we can achieve a pretty good level of civil rights protections in this country. As I said, our system is not set up, and no system in the world is set up where you can treat everybody exactly the same, because sometimes it's not prudent. It's not correct to treat everybody exactly the same. I think I used the example in the last chapter that if I have 2 students come to me, one of them tells me that they missed the exam because they were drunk last night, and another student comes to me and says they missed the exam because all 4 of their grandparents were killed in an auto accident last night. Treating them exactly the same by saying, yes, they can both take the exam, or no, neither of them can take the exam, is not the way the situation should be treated. So I should be treating them equitably. I give the person who could not control the fact that they missed the exam the opportunity to take it again, but I tell the person who could control it by not getting drunk that, no, I'm not going to let you take the exam. And that is kind of the way our government deals with civil rights. We don't treat everybody exactly the same. We treat them as close as the same based on the circumstances. As a matter of fact, in this country, when we talk about civil rights or equal rights, the word discrimination comes up. Oftentimes when we look at civil rights issues, we talk about the fact that the government discriminated against this person, or the government discriminated against this group of people. And we as Americans look at that word discriminate and say, that's wrong. It's illegal. Shouldn't be done, can't be done. But in fact, the Supreme Court have said over and over and over again that there's times when it is legal to discriminate, because the word discriminate basically means to treat differently. I treat the student that was too drunk to take my test differently than I treat the student whose grandparents died in an auto wreck. I'm discriminating. I'm treating them differently, but I am treating them differently based on some legitimate reason. So we're going to take a look and try to explain to you guys, when has the Supreme Court said it's okay for the government to discriminate and when they can't. To try and clarify when the Supreme Court says it's okay for government to discriminate and when it is not okay for them to discriminate, the Supreme Court has done what they've done with a lot of issues. They've created what we call tests or standards. And when it comes to when the government can discriminate and when they can't, there's 3 tests or standards that I want you to understand. And those tests and standards are the reasonable basis test, the intermediate scrutiny test, and the strict scrutiny test. Now, there are 3 different tests there. How do we know which of those 3 tests the Supreme Court will use in my case? If I am suing the government saying that the government has illegally discriminated against me, which of these 3 tests will the Supreme Court use? To understand that, we need to understand the concept of what we call suspect classification. And what a suspect classification is, what characteristic about myself am I saying is the reason that the government is discriminating against me? That's what a suspect classification is. If I say that the government is discriminating against me because I have blue eyes, then the color of my eyes would be my suspect classification. If I'm saying the government is discriminating against me because I'm a political science professor, that would be the suspect classification. But generally, the three suspect classifications that I want you to be familiar with, the three most common suspect classifications, are age, gender, and race or ethnicity. So if the government is treating me differently because of my age, that would be the suspect classification. And the government, the Supreme Court, has to determine what the suspect classification is before they can determine which test they're going to use. And let me give you some examples. For example, if the suspect classification that I am suing because of is age, the Supreme Court has come up with what they call the reasonable basis test. And the reasonable basis test sounds very much what it says. The government can discriminate based on age if they have a reasonable basis for doing it. For example, when we look at driver's license, when I went to get my driver's license several years ago, I was given my driver's license for 7 or 8 years. I didn't have to come back for 7 or 8 years. But yet, a very good friend of mine at church was told you have to come back and get your driver's license every 2 years. And why was he told that? Because he was 92 years old. The only difference between me and him is our age. Now, is it reasonable for the state of Missouri to ask older people to come in and get their driver's license more frequently? And the Supreme Court has said yes, because it is a reasonable expectation that a 90-year-old's vision and reaction and physical ability to drive is going to diminish much more quickly than a 45-year-old. So the Supreme Court has very clearly said you can discriminate based on age when it comes to driver's license. Another example is voting. The government is allowed to discriminate. They can say no to a 17-year-old. You can't vote if you're 17, but when you turn 18, you're allowed to. And the basis for that is that younger people don't tend to think about their choices, and they don't tend to, make as good of decisions. That's at least the basis behind that law. There has to be an age where, we don't want to let 6-year-olds vote, and it's reasonable to have some age, and the Supreme Court has said that's fine. And you'll see with the button that I put up there, it's kind of an old button. At one point, the voting age in this country was 21. And then the next example where you can discriminate based on age, of course, would be alcohol. They're treating you differently if you're under the age of 21 than if you're over the age of 21. And there's a reasonable basis for that, because younger people, for the most part, don't have the ability to make good choices when it comes to alcohol and driving or alcohol and other activities. So the Supreme Court has said, if you're going to discriminate based on age, all you got to do is prove that the government has a reasonable basis for doing it. It's the easiest to prove. Our next suspect classification is gender discrimination. Or if the government is going to discriminate against me based on my gender, the government has to do more than just say that they have a reasonable basis for it. They have to have more evidence. The government is going to, or the court is going to scrutinize that law that discriminates based on gender more than they do a law that is based on age. And you have to have some evidence. You have to have some legitimate, solid proof that this discrimination is necessary. And a couple of examples that I'll give you. The draft. Men have to sign up for the selective service. Women don't. Another example, women in combat. Are women allowed in combat? Let me rephrase the question. Are women allowed in permanent combat situations? And the answer to that is no. And let me clarify this a little bit. You'll see from this picture, women are allowed on combat ships. Women are allowed to fly combat missions with helicopters and airplanes. But women are not allowed to be permanently stationed on the front lines. For example, if men were in a foxhole, women would not be allowed to be permanently stationed in the foxhole with the men. And why is that? The Supreme Court is very clear. The Supreme Court says the reason that women are not allowed to be permanently stationed in forward combat units is because women are physically stationed different than men. And what does that mean? Does that mean that women are weaker than men? That's a general belief. It would be reasonable to assume that men are stronger than women. But I guarantee you there's lots of women who can kick my butt. This is not what the Supreme Court means here when they say women are physically stationed different than men. The Supreme Court says there is proof that there's something different about women that prevent them from being able to effectively and permanently be left in combat. And a lot of us don't like to talk about this, but what it is women menstruate. Women, once a month or every so many days, have to be able to take a shower. They have to be able to clean themselves. And if they don't clean themselves, if they don't shower, it's not just a problem that they're going to become odoriferous and start smelling. It's going to cause a real physical concern because they're going to start to get infections, and those infections can be passed on to men. So this woman on the Navy ship, I'm assuming she menstruates, but why can she be on a combat ship but not in the foxhole? Because on that Navy ship she can take a shower. She has access to what she needs during her week or so that she's menstruating. A woman that flies a combat helicopter can fly in, drop her ordnance, and fly back out. And if she happens to be menstruating during that mission, she can come back to the rear and, take a shower and take care of her physical needs. That is based on the concept of intermediate scrutiny. The Supreme Court has looked at this and said there's real solid evidence that this discrimination is necessary. Now, the third example, or the third suspect classification we'd like to talk about, is racial or ethnic discrimination. If the government is discriminating based on a person's race or ethnicity, they've got a whole new test that they have to meet, and that's called the strict scrutiny test. And basically what the strict scrutiny test says, you have to have compelling proof that this discrimination is necessary. You have to really, really, really show the court that this discrimination is necessary. It's the toughest test to pass, and it's the toughest classification for me to come up with examples where the Supreme Court said racial discrimination is legal. But the one that I'm thinking about is affirmative action. If we think about affirmative action is basically when certain racial or ethnic groups get a little bit of an advantage when it comes to certain things. For example, if the government was giving a contract to build a new water treatment plant, affirmative action says we're going to give priority or extra points to racially or minority-owned businesses. And the reason that they say this, and the reason that they say that affirmative action, the discrimination that we see in affirmative action programs is okay, is because in the past there was very negative discrimination against certain groups. For example, racial groups. In the past, in the not very distant past, if there was a contract to build a water treatment plant, the government would have very, very purposely denied minority-owned businesses from that contract. And that was wrong. And the Supreme Court and the country realized that was wrong. And what the Supreme Court says is to try and make up for that past discrimination, affirmative action or racial discrimination is okay. Make sure you're aware of the 3 suspect classifications that we talked about here, and also make sure you know which test is used with each suspect classification.